disputes, such as the instant one, could not have been stated more conscientiously and more effectively than it was in that case, as follows, quote, by the design of the general principles of the electoral system and of voting in Articles 81 and 86 of the Constitution, it is envisaged that no electoral malpractice or impropriety will occur that impairs the conduct of elections. This is the basis for the public expectation that elections are valid until the contrary is shown, end of quote. A consideration of the merits of an electoral petition, such as the instant one, therefore, takes one straight back to the evidence tendered. So we get back to evidence. And hence there is an inseparable link between institutional principle and the pillars of evidence. Since, as I have already determined, the petition herein fails on the pillars of evidence, it becomes clear that the majority decision lacks validity from the standpoint of governing principles. Evidence is the bearer of telltale signs of electoral victory or of electoral defeat. The physical form of the ballot is directly visible and is readily subjected to the test of simplicity, accuracy, verifiability, security, accountability, and transparency. This physical evidence quite clearly is the natural starting point in ascertaining who has won an election, and hence the majority judgment would have been expected to begin from a foundation of numerical assessment before invoking any other parameters. For such other elements are essentially subjective and are inherently destined to compromise the sovereign will of the voters, which the Constitution expressly safeguards. Only from such a foundation of the physical vote count does one secure a proper viewpoint for the other dimensions of the electoral process, including the credibility of the entire operation. Indeed, in view of the relative strength of the evidence emanating from the two sides, the only objective conclusion would have been that, within the measure of the possible, the conduct of the election by the first respondent was entirely credible. The emerging principle regarding the initiation of claims by way of election petitions is that all proof should commence from the foundation of the physical ascertainment of voting records. All other claims then must revolve around that pillar and must establish that some gross impropriety had affected the electoral process and should lead to its annulment. I am constrained to propose this scheme as a proper agenda for the reform of Kenya's electoral law. Such legal reform would need to institute all appropriate security backups around the physical records and would ensure the establishment of safety nets around the votes cast. The instant case has evoked intense national debate involving professionals, politicians, observers, and others. The consequence being a justification in this judgment for a clarification of the implications of judicial intervention in situations that entail the legitimate exercise of the citizens' momentary inclinations on matters of politics and daily exigency. Falling squarely within such a category are the people's legitimate preferences. What is the proper stand for the Supreme Court in such matters? How does the judge's requisite approach relate to the majority decision in the instant petition? My consideration of such issues confirms my position in this dissenting judgment. By Article 160, Sub-Article 1 of the Constitution, is provided the judiciary, quote, the judiciary shall be subject only to this Constitution and the law and shall not be subject to the control or direction of any person or authority, end of quote. The Constitution, while safeguarding the judiciary's adjudicatory space, entrusts certain governance spaces to other agencies, primarily the legislature and the executive. And this is the basis for the constitutional principle known as the separation of powers, a principle the validity of which in the Kenyan constitutional order has not ever been seriously contested. The judiciary is a trustee of the people's sovereign power, Article 1(3), with regard to the interpretation and application of all the terms of the Constitution and of all other law. Clearly, a substantial initiative in the motions of the entire sphere of law, legality, and jurisprudence has been reserved to the courts. As the outer limits of such reserved competence has not been specified in express terms, it follows that the frontier areas of such power, at least potentially, admit of conflicting interpretive approaches. But, as already noted earlier, the proper trustee of the boundary delimiting ethics must be the judiciary, an arm of the state which is endowed with the special facility of juristic values, objective criteria of conflict resolution, a placid mean such as facilitates professionalism, justice, and fairness, and the benefit of access to relevant comparative lessons. The judiciary, in the exercise of such an exclusive mandate, ought to enter upon its task by taking into account the uncontestable reserved remits of the other agencies of the state. The people, in exercise of their sovereign power, have expressly delegated some of that power to Parliament and the legislative assemblies in county governments, Article 1(3)(a), and they have exclusively entrusted some of their sovereign powers to, quote, the national executive and the executive structures in county governments, end of quote. There is no basis for abridging Parliament's power and mandate. For the Constitution, Article 94(1) prescribes that, quote, the legislative authority of the Republic is derived from the people and at the national level is vested in and exercised by Parliament, end of quote. Similarly, there is no basis for detracting from the general character of the executive power. Article 1291 prescribes that, quote, the executive authority derives from the people of Kenya and shall be exercised in accordance with this Constitution, end of quote. Unlike the judiciary, the work orbit of which is lined up with laws, principles, and jurisprudential yardsticks, both the legislature and the executive, in view of their electoral and policy foundations, may quite properly be described as political agencies. They relate to the largest number of Kenyan people in a close and direct proximity. They influence and are influenced by the momentary concerns which therefore justify the conception and espousal of policy and politics conceived and executed within short time frames. This is in stark contrast with the relationship between the ordinary citizen and the courts of law. And if the courts overlook this reality, it will constitute a groundswell for failure of judicial responses in line with the professional juristic remit. The prolonged history of judicialism in all democratic countries demonstrates that the proper role of the courts has been professional, judicial, and founded upon cardinal principles which draw lines of correctness and propriety in situations of dispute so as to secure a certain optimum level of safeguards for the rights of the citizen. Beyond that level of safeguard and fulfillment, it falls to the political agencies to pursue constantly such policy stance as will satisfy and give fulfillment to the national populace. On these principles of institutional disposition, it follows that it falls not to the court to make undue haste in assuming the policy and political mantle. A stampede is destined not only to disrupt the delicate institutional balances, but to weaken the reliable jurisprudential bedrock, which assures the citizens of an ultimate governance safety net. In the context of the foregoing reasoning, it follows, in my view, that the majority on the instant petition has made a precarious move that is destined to prove detrimental to the dependable setting of relations among essential governance entities, to the detriment of the rights and legitimate expectations of the citizen. What the majority has said is set out, and you have already seen it. And they have made their orders in a manner that you know. Such a determination is in clear departure, in the first place, from the state of the evidence. As already indicated herein, the petitioner's case rests on just one dimension of the electoral process: electronic transmission of results. Moreover, the bulk of the assertions made as regards transmission is just that, contentions with only limited testimonial ingredient. It is hardly evidence, what Black's Law Dictionary calls something including testimony, documents, tangible objects, that tends to prove or disprove the existence of an alleged fact. That is evidence which I'm looking for. On the other hand, evidence in the true sense, a set of probative facts, is what came forth from the respondents. And its tenor and effect was that there were only limited instances of failure of results transmission. Only limited cases of irregularity in vote addition and tabulation, not affecting the ultimate compilation and summation. The lawful complementary device was put in service in cases of failure in the transmission process. All the physical voting records were avoidable and indeed had been timeously availed to the Supreme Court registry. All the physical voting records were available and indeed had been timeously availed to the Supreme Court registry and could have been recounted to confirm the third respondent had been properly declared as president or not. Thus, on basic elements of trial, the essence of burden of proof was undischarged, and it was in effect a reversal of the conventional process of judicial inquiry and determination, making a finding in favor of the petitioners. Secondly, the majority would appear to have taken leave of the juristic obligation to interpret the terms of the articles of the Constitution invoked by the petitioners. The obligation to break this down so as to ascertain the discrete demands of the law, the obligation to consider the pertinence of the specific statements of evidence from the petitioners, such as would answer to the constitutional and legal principles invoked. Thirdly, the majority departed, as it would seem, from the placid frame of the juridical setting and assumed direct responsibility for the immediate calls of policy or politics by altering the design of momentary popular inclinations, which are, by the terms of the Constitution, legitimate in all respects. The damage such as may flow from such a deportment is not yet plain to all, as is quite clear from common perceptions recorded in the media ever since the delivery of the majority judgment. I can quote just one. Quote, "What we have experienced as a nation is definitely a shift. The recent ruling by the Supreme Court to nullify a presidential election has never happened before in the history of this nation, or even this continent. But it is undoubtedly a political and judicial shift that has risen from the years of tectonic plates of power pushing on each other within a constricted democratic space." End of quote. The general perception associates the majority judgment with an overtly political inclination. This precisely is the judgment's obvious departure from the professional plane of jurisprudence as the proper platform of the judicial arm of the state. The majority position would, of course, make history emanating from basic principle, and in this regard, I cite a passage from a distinguished scholar of history, Professor Goat. He says, quote, "To tell the story of a past so as to portray an inevitable destiny is for humankind a need as universal as tool-making. To that extent, we may say that a human being is by nature historicus," end of quote. So, by, quote, "the magic jolt of the 1st of September 2017, general political history would have been made, even though, as I maintain, this represents a departure from the jurisprudence of democratic systems, which so much cherishes the separation of powers and which so studiously commits the judiciary to the professional task of line drawing to ensure the sustenance of regular safeguards of the Constitution and the law for all. In future inquiries, it may be established that the law, as advanced by its interpreters and scholars, has its anchorage on the adjectival plane from which it addresses the primary motions of social, economic, and political activity: agriculture, architecture, engineering, land development, seafaring, sport, transport, communications, and so on. The law stands to be formulated, molded, interpreted, and applied, not for his own sake and in his own cause, but in relation to the said primary motions which preoccupy citizens and communities. Thus, in the instant case, the electoral process had taken place, and now its motions had to be matched to the law as interpreted. By the interpretive scheme of the law, it does not stand the test of rationality or efficacy to merely allege some unspecified impropriety in the electoral process. The relevant clause of the Constitution must be taken through an analytical process and subjected to definite categorizations which crystallize the specific concepts and elements said to have been violated. By this criterion, most of the contentions of the petitioners in the instant case, on account of their broad generality, would not stand up. The interpretive task, as it thus relates to the adjectival essence of the law, is inherently professional and is reflected in the concept of jurisprudence, which means, in the words of a distinguished scholar, R.W.M. Dyers, it deals with thought about law. The court, in the normal framework of its role under the Constitution, is engaged in the specialized process of jurisprudence. It follows that the more immediate, urgent, and primary motions of basic policy making inherently devolve the political arms of the state rather than the more specialized entity which is the judiciary. This judgment, apart from the occasion it proffers for reflection on the law relating to elections, is a basis for a rethink on law as a concept and as a professional engagement defined in a regulatory framework applicable to the citizens' primary undertakings. From such a platform, it emerges that the laws designed in the hands of the judge, the lawyer, the scholar, rests in unity with the fundamentals of constitutional governance, an important element of which is the independence of the judiciary. On the basis of this principle, it is to be recognized that the judge's proper mandate lies several removes from the citizens' momentary policy and political desires and expectations, which generally devolve the political arms of the state. By this perception, the judge's proper remit has its focus upon professional engagement founded upon objective scenarios or criteria. Such a perception of law and legal process, in retrospect, will be found to be in conformity with the analytical schemes that mark the dedicated works of great jurists of the past. And in this regard, I would mention, I've given references, Lord Mansfield, Professor Frederick William Maitland, Lord Atkin, Justice Oliver Wendell Holmes, Justice Benjamin Nathan Cardozo, Professor Stanley Alexander D. Smith, Lord Denny. The special contribution of these judges and law scholars was to light up the orbit of jurisprudence as a dedicated sphere of thought, learning, and preoccupation that secured the requisite motions of the different spheres of human activity, while affirming the perceptions of integrity and propriety. Such is the jurisprudential context in which I have considered the petition hearing. The majority decision, in effect, holds that the court may quite directly engage the course of national history through a precipitate assumption of recurrent policy making or political inclinations and mandates. In my considered opinion, judges, where the making of history devolves to them, should focus their attention in the first place upon the intellectual and jurisprudential domain, rather than upon the workaday emotions of general policy and politics, which devolve to the citizens themselves and to the political agencies of the state. On these principles, on these premises, I hold that the majority decision fails to resonate with the Constitution and the law, and with all relevant guiding principles, I would dismiss the petition with costs. That is the decision that I have given.